Go ahead. 9:45.
Committee on State Affairs will come to order. Pass the gavel to Chairman Schwerter.
Thank you, sir. Chair lays out Senate Bill 945 and recognizes Chairman Hughes on his bill.
Thank you, Mr. Chairman. Senate Bill 945 is about insurance-specific cases of shareholder activists trying to impose their political agenda for purposes outside of business objectives. The idea is a common theme, sadly, in the last few years, where folks who cannot get their ideas passed into law at the ballot box or the legislature will instead try to do it through corporate mechanisms and through basically various forms of ESG. One recent case is a group called As You Sow. Their website describes their organization like this, I'm quoting, "Our mission is to promote environmental and social corporate responsibility through shareholder advocacy, coalition building, and innovative legal strategies. Corporations are responsible for most of the pressing social and environmental problems we face today. We believe corporations must be a willing part of the solutions. We make that happen. As shareholder advocates, we directly engage corporate CEOs, senior management, and institutional investors to change corporations from the inside out," end quote. In recent years, they've proposed resolutions at multiple insurance companies to require the insurers to track greenhouse gas emissions at the oil and gas companies they insure. These resolutions aren't designed to help the insurance company provide better insurance. They're designed to achieve a political end that their proponents cannot achieve by political means. Knowing that this information does not serve a business purpose and may hamper their ability to provide objective, risk-based insurance to a certain class of companies, the insurance companies that are the target of these proposals ask the SEC to allow them to forego voting on the resolutions. It's not surprising that the Biden administration's SEC ruled against the companies in favor of activist shareholders, forcing the vote. And these practices have real consequences. Energy is a critical part of our state's economy, whether we talk about the good, high-paying jobs, all the other collateral benefits, and what everyone enjoys from low-cost, reliable energy that affects the price of every product we purchase. If we want to help working families and real people, we need cheap, reliable energy. These policies go in the opposite direction. So Senate Bill 945 will shield Texas-based companies from having to present or implement shareholder proposals. They're designed to prohibit or limit providing insurance to oil and gas companies solely because they're oil and gas companies, require the insurance company to track greenhouse gas emissions of their insured clients, or prohibit or limit the provision of insurance based on environmental, social, or political ends. The Senate passed this bill last session. It ran out of time in the House, so hopefully we'll get it over to them a little earlier this time, and I'll yield.
Thank you, Senator. Members' questions? That we're going to open up public testimony. There are three wishing to testify. The chair calls Jason Isaac, Will Hild, and Jack McFerrin. Invited. Mr. Isaac, since we know you.
Yeah, all right, thank you. Thank you, members. Thank you, Mr. Chairman.
Please state your name, position, and
Jason Isaac, the American Energy Institute, in support of Senate Bill 945. Thank you, Chairman Hughes and members of the committee and staff for the opportunity to be here. My name is Jason Isaac, again, CEO of the American Energy Institute, a rise in strong support of Senate Bill 945, critical measure to shield Texas insurers and their policyholders from the growing wave of politically motivated shareholder activism. We've seen what happens when large asset managers hijack corporate governance. They use proxy votes to push radical environmental and social agendas that have nothing to do with risk management or returns and everything to do with coercion. Senate Bill 945 draws a firm line in the sand, protecting insurers from being weaponized against the very industries that power this country. Senate Bill 945 ensures that Texas-based industries stay in the business of underwriting risk, not underwriting politics. This is about protecting the rule of law, economic freedom, and the industries that sustain our prosperity. The people of Texas didn't elect financial institutions from Wall Street or activist nonprofits to set energy policy. We elected you, and this bill defends that authority. I urge the committee to support Senate Bill 945 and keep Texas insurance markets focused on their core mission, serving Texas, not political ideologues. The discriminatory practices we're fighting against are not abstract. They are happening to organizations like mine in real time. Earlier this year, the American Energy Institute, the organization I lead, received a formal notice of non-renewal from the Hartford. Despite having an active and compliant policy, we were informed that our policy was no longer going to be renewed at the end of May because the Hartford determined from our Facebook page that we are a trade association, in quotes, involved in promoting social/political causes related to energy production, end quote. Let that sink in. Promoting American energy, the very lifeblood of Texas economy, the thing that's necessary to end poverty around the world, is now considered an unacceptable risk by a major insurance provider. This is exactly the kind of viewpoint-based discrimination that Senate Bill 945 seeks to eliminate. If this ESG ideology can justify denying insurance to a nonprofit that supports energy producers, then it can happen to anyone or any person in our industry. It sends a chilling message to conform to the political orthodoxy or lose access to basic financial services, including insurance. Hope Texas responds clearly and forcibly by passing Senate Bill 945 that'll help ensure that insurers operating in our state do so based on legitimate underwriting risk, not the ideological preferences that their home offices in Connecticut or New York would prefer. This is about economic sovereignty. It's about protecting Texas energy, jobs, and the freedom to speak openly in support of our way of life. Thank you for the opportunity to testify.
Thank you, sir. Any questions? Mr. McFerrin?
Thank you for inviting me to speak on this bill. My name is Jack McFerrin. I'm a research fellow with Heartland Impact. ESG-driven financial discrimination against entire groups, whether they're industries, companies, or individuals, has been prolific. A lot of the attention has been placed upon financial institutions that lend or provide access to credit, but not enough is placed on insurance companies. And so I have some testimony related to more general financial discrimination by lenders, but I'm going to focus here on the insurance companies. Many major insurance companies across the globe have implemented policies refusing to underwrite fossil fuel projects, including Allianz, AXA, Swiss Re, Munich Re, Zurich Insurance Group, the Hartford, Chubb, and AIG, among many more. For a recent example, in 2024, Zurich announced it would cease underwriting new oil and gas exploration and development projects, as well as metallurgic coal mining. Zurich also now requires its highest emitting corporate clients to adopt credible climate transition plans aligned with a 1.5 degrees Celsius pathway and the goal of net zero emissions by 2050. The company has stated it will review these clients' progress and may terminate relationships that fail to show sufficient transition momentum. Chubb updated its policies in 2024 as well. It announced that it would continue to provide coverage for oil and gas producers with annual revenues greater than $1 billion that are demonstrating progress towards achieving near zero methane emissions, which is 0.2%, but that it may, quote, decline coverage if a potential policyholder cannot meet our methane performance expectations. And then in August of 2024, Chubb withdrew its insurance company for the Rio Grande liquefied natural gas project in Brownsville, Texas, one of the largest proposed fossil fuel infrastructure investments in the state. Ultimately, ESG-driven financial discrimination, whether carried out by investment firms or insurance conglomerates or banks, imposes political orthodoxy at the expense of sound risk assessment, consumer choice, and economic vitality. The common sense provisions in this bill would go far in protecting the Texas economy and Texas companies from discrimination and denial of basic financial services. It would also ensure that radical activists, many from outside of this state and outside of this country, will not control the means of production and curtail the freedoms of each and every citizen of this state. Thank you for your time.
Thank you, Mr. McFerrin. Mr. Hild, Will Hild?
Yes.
Welcome, sir.
William Hild from Consumers Research. Thank you, committee and chair, for the opportunity to speak in support of this bill today. I'm so glad that you're taking this up. I and my organization reject the definition of ESG that's often given by its proponents, that it's a style of investment strategy or risk management. What it really is, in effect, is an attempt by those in the financial services industry across many categories, but at least 4 major ones, to use their market share to force through a far-left agenda on the American public without ever having to face the voters, the people that elect those in this room, and expect them to set energy policy, as the other witness said. And I am so glad to see this committee and this chamber and this state take up specifically the issue of insurance, because it is a key area where that pivotal role that insurance plays in allowing the flow of business and the creation of businesses can be leveraged in multiple different ways inappropriately to push an illegitimate agenda. Specifically, we talked about the ways in which ESG discrimination makes it hard for people to get insurance if certain industries or types of activities are either fully boycotted or throttled. But in addition to that, there is an attempt to hijack a number of these companies because of their large financial holdings that they have, obviously in the case that they have to make payouts and for the annuities that they will then owe. There's also an attempt to hijack these companies and turn them into similar activist investors, much like we've seen from BlackRock and State Street. So I think this is a very important bill because, one, it will help prevent any kind of ESG discrimination against people when they're seeking insurance and make sure that the analysis is stuck to the real risk factors. But in addition to that, it puts down a marker to say we're not going to let activists take over another holding. And I would just say that there are people I know of inside the insurance industry who get pressured from large asset managers. I think we're going to discuss later today, like BlackRock and State Street. And this bill will help them when they disagree, when they don't want to do this. It will give them a reason to say, I can't, because it's illegal. Because a lot of times right now, when they're saying, we think it's a minority shareholder that's still very large, like BlackRock or State Street, meets with these companies and says, we would like to see you engage on these net zero issues and change the way you treat your customers because of that. They don't have anything to point to except a disagreement of opinion. If this law passes, they will be able to say, I cannot do that. That violates the law. And that will be a great defense to the people who just want to engage in insurance business as such and not play politics.
Thank you, sir. Members, questions of this panel? We thank y'all for being here. Anyone else wish to testify? Hearing none, we're going to close public testimony on Senate Bill 945 and leave the bill pending. Senator 946. All right, thanks. Okay. Chair lays out Senate Bill 946 and Senator Hughes is recognized on his bill. Chairman Hughes.
Thank you, Mr. Chairman. Senate Bill 946. This is about creditors and discriminating based on a social credit score. Right now, the law prevents creditors from discriminating against an individual due to sex, race, color, religion, national origin, marital status, and age. However, these provisions do not prohibit a credit issuer from denying an organization's extended credit request due to its political or religious affiliations. So that means lenders can freely discriminate against political and religious groups. Senate Bill 946 would protect organizations from being denied an extension of a loan or a limitation to the credit extended for any reason other than failing to meet impartial and non-subjective standards established by the lender. Impermissible reasons for rejection include use of a social credit score or an environmental social governance score not drawn from empirical reasoning. Also, this bill would prohibit discrimination due to an organization's practices of diversity, equity, or inclusion, as well as its association, service, or cooperation with a religious institution or a legal industry. And that's what the bill does.
Thank you, Senator. Members, questions? Hearing none, we're going to open up public testimony. Chair calls Jason Isaac and Will Hild as invited testimony. And then Lathan Watts and Jack McFerrin again. Mr. Isaac?
It's like deja vu all over again. Good evening, Jason Isaac, CEO of the American Energy Institute, in strong support of Senate Bill 946. Timely and essential defense of fair and non-discriminatory access to capital for Texas businesses is critical. Senate Bill 946 addresses an alarming trend we've seen across the country, where financial institutions are increasingly denying credit to businesses, not because of risk, but because of political ideology. Let's be clear, credit decisions should be based on financial fundamentals, not whether a company aligns with the woke priorities of Wall Street or Silicon Valley. This viewpoint discrimination, plain and simple, has no place in Texas. The ability to access credit is foundational to liberty and economic opportunity. If we allow social scoring to creep into lending decisions, we risk creating a two-tiered economy, one where your values determine whether you can build a business, buy land, or get insurance. We've already seen clear and egregious examples of the discriminatory practice in action right here in Texas. James Lofton, a successful oil and gas entrepreneur from Odessa, shared his story with lawmakers during testimony for the House companion to what would become Senate Bill 13 in 2021. Despite strong financials, a perfect repayment history, no overextension of credit, his company's $500,000 line of credit was abruptly canceled by his bank. The reason? Oil and gas, in quotes, was no longer a market they were interested in quotes. This wasn't about risk, it was about politics. His business, JAN Resources, and its 35 employees were put in jeopardy because of a financial institution targeting companies that just service oil and gas companies. Well, what can only be described as an act of ESG-motivated economic punishment. Fortunately, Texas banks stepped up, including Frost Bank, but this episode illustrates why SB 946 is needed. We must not allow financial institutions to impose political litmus tests on which lawful industries are deemed worthy of credit. Another example from the now defunct Credit Suisse First Boston's chairman of global energy and transition. I don't think he was planning to transition himself out of a job, but their ESG embracing certainly led to that. Sent a letter to one of my members, said, in quotes, please see the below bullets, which will make sure that our firm's sustainability policy is aligned with yours. By tweeting these, everyone will agree there is no misunderstanding. Agree that company activities should be aligned with the Paris Agreement. Believe that companies should have a commitment to achieve net zero emissions by 2050. Agree that climate change is occurring and that carbon is contributing to climate change and global warming, end quote. This was necessary to get a funding round for an entrepreneur here in Austin. Fortunately, the entrepreneur chose other means of securing funding. SB 946 sends a strong message that in Texas, access to capital must be based on merit, not ideological conformity. No business or person should be denied a loan for providing the energy that powers our homes, vehicles, and our economy. Appreciate the opportunity to testify today in support of Senate Bill 946.
Thank you. Members' questions? Mr. Hild, Will Hild.
Certainly. Well, in addition to insurers, banks have also embraced discrimination based on emissions, leading to similar harms. Banks in the Net Zero Banking Alliance have pledged to transition all operational and attributable GHG emissions from their lending and investment portfolios to align with pathways to net zero by mid-century or sooner, consistent with a maximum temperature rise of 1.5 Celsius above pre-industrial levels by 2100. Though the NZBA recently modified its guidelines still state that targets should align with the goals of the Paris Agreement. A number of U.S. banks recently left NZBA, but many of those same banks have expressed their continued support for GFANZ, which organize the Net Zero Bankers Alliance and works to, quote unquote, support efforts within the financial services sector to achieve the Paris objectives. The CEOs of Bank of America and Citi remain members of the GFANZ Principles Group. JP Morgan Chase also promised that it will, quote unquote, will continue working with GFANZ on advancing solutions and the market conditions that can help further a low carbon future. Many of the banks that left NZBA also continue to embrace the net zero targets they created pursuant to their NZBA commitments. For example, Morgan Stanley remains steadfast in its commitment to net zero and will continue to engage with clients on climate transition strategies to help move the world to net zero emissions by 2050. Morgan Stanley maintains the targets it set under NZBA and claims that those targets are, quote unquote, realistic. Yet its targets are between 1.5 and 1.7 Celsius, both of which are even lower than the 1.9 best-case scenario, according to their own research. Nevertheless, Morgan Stanley's net zero targets will help determine, quote unquote, how the firm allocates capital. So we're talking about direct discrimination about how they will use their loan portfolio. Citi continues to tout its commitment to reach net zero greenhouse emissions by 2050, including our own operations by 2030. In order to reach this goal, Citi calculates its emissions for each sector and sets emission reduction targets. Although Citi claims it will reach its targets by working with our clients and helping them in their low carbon transition, if those efforts fail, Citi clearly will need to restrict its lending based on emissions in order to meet its goals. Bank of America has also maintained its net zero finance emissions target, and JP Morgan has maintained its NZBA net zero financing targets. Banks continue to discriminate on lending based on emissions. Banks that left NZBA still appear to be using emissions to discriminate in lending, which will harm America's economy, especially its energy and agricultural sectors. For example, JP Morgan Chase is working to align key sectors of its financing portfolio with its net zero targets. In order to pursue those targets, the bank gives each client a carbon assessment framework. This is similar to a social credit score under a different name, based on their historical, current, and future emissions. Bankers are required to consider CAF scores for new proposed in-scope transaction and consider how the transaction may impact a portfolio's quote-unquote carbon intensity. If they do not, JP Morgan Chase has systems to hold quote-unquote senior leaders at regional and sector-specific levels accountable for progress towards those goals. So they're talking about incentivizing their own executives or disincentivizing, as the case may be. In short, JP Morgan Chase is factoring in client emissions into decisions and threatening consequences for senior managers that do business with clients whose emissions could prevent the bank from reaching its net zero targets. Similarly, Bank of America has stated that it evaluates every client's emissions and their transition plans. It even assigns each client a climate and environmental risk assessment score based on their climate and environmental vulnerabilities, which is then integrated into Bank of America's underwriting and credit risk lifecycle. The CIRA consideration includes risk factors such as management's awareness of climate. This gets exactly to the previous witness's discussion of forced speech in order to get financing. And the degree of sector-subsector risk. Bank of America further explains that it places information on a client's emission profile and their impact on the overall portfolio on a dashboard for frontline bankers and senior managers. Isn't that great? When you walk into their bank, your banker knows whether you've got a good credit score or not, or a good carbon credit score. It's wonderful. They can treat you better or worse based on how you're doing. As a decision-useful metric to drive progress towards the bank's net zero goals. And the bank boasts that it is an entire group of senior leaders who are directly responsible for monitoring progress towards the bank's sector GHG emission targets. Banks continue to use tools like these in combination with net zero targets will inevitably have to discriminate based on emissions, especially in energy and agriculture sectors. This is especially true given that net zero pathways and goals are becoming ever more impossible to meet. Thank you.
Thank you, sir. Members' questions? Latham Watts, you're recognized, sir. You have 2 minutes, 3 minutes.
Good evening, Mr. Chairman, members of the committee. I thank you for the opportunity. Latham Watts with ADF Action, the sister organization to Alliance Defending Freedom. Appreciate the opportunity to be here. During the 1930s, in an abhorrent practice known as redlining, financial institutions created maps with certain neighborhoods marked in red. Lenders viewed residents of these neighborhoods as hazardous or too risky and would not issue them home loans. But as we know, such redlining was not based on financial risk. It was based on racial discrimination against predominantly black neighborhoods. Today, we are seeing a growing threat of a modern-day version of redlining. What large banks now label as reputational risk is just a cover for discrimination against businesses and individuals because they are affiliated with either the oil and gas industry, the firearms industry, or because of their religious or political beliefs. No one should fear losing their bank account, credit card, or access to credit or other financial services because of their free speech or their support of the Second Amendment or their opposition to ESG or DEI. The founders of our country were keenly aware of the threat to liberty posed by the concentration of power in government. And the Constitution they crafted, when it is adhered to, alleviates that threat. The concentration of power in the private sector is a similar threat to the God-given right to the pursuit of happiness. Access to basic financial services is necessary to participate in a free market economy. And for a free market economy to be truly free, it must be free of discrimination. Moreover, banks that are too big to fail are too big to discriminate. And if we're going to have again, a free market economy, it must be free from discrimination. Certainly, banks can engage in fiscal analysis in order to make sound investments. But an ideological shibboleth has no place in that analysis. And so I commend the chairman for his efforts in this area, and also Senator Parker for his bill 949 in this area, and we are here to help. Thank you.
Thank you. You registered on the bill.
Yes, sir.
I mean, for or on? You wanted-
On the bill.
On the bill. All
Yeah.
right. Thank you, sir. Mr. McFerrin, you're recognized. You have 2 minutes, 3 minutes.
Chairman Hughes, members of the committee, thank you for inviting me to speak. My name is Jack McFerrin, research fellow with Heartland Impact. Most of what I was going to say has already been covered pretty well, so I won't waste your time rehashing it. But what I will say is that this bill is absolutely crucial, and in my written testimony, I go into much more detail, but the discrimination against oil, gas, and coal companies, gun manufacturers and ammunition manufacturers, religious organizations, agricultural producers, it has been, as I said before, endemic, and this bill will prevent all of that if you pass it. And in my opinion, of the 4 ESG bills being considered today, this is the most important one, and I strongly urge you to pass it.
Thank you, sir. Members, questions of this panel? Thank you all. Y'all are excused. With that, we're going to close public testimony and leave Senate Bill 946 pending.
The chair now lays out, and thanking Chairman Schwartner, the chair now lays out Senate Bill 2044, and recognizes its author, Senator Betancourt, to explain the measure.
Thank you, Mr. Chairman, members. I do have a committee substitute for Senate Bill 2044.
Senator Schwartner sends up the committee substitute. Senator Betancourt is recognized to explain the substitute.
Thank you, Mr. Chairman. Over the last year, we've seen an extreme rise in electioneering issues throughout Texas. The Texas AG office filed suits against multiple independent school districts for electioneering violations in 2024. They included Denton ISD, Frisco ISD, Denison ISD, Castleberry ISD. And Senate Bill 2044 strengthens existing strengthens existing electioneering laws and creates new statutes to forbid publicly funded education institutions and personnel from using official resources to promote political agendas. The bill basically defines electioneering as posting, using, distributing political signs or literature, posting, endorsing, or expressing support for or opposition to a measure before a governing body other than a school, engaging in conduct prohibited under the election code, and to include, and there's a fairly extensive list on that. And the committee substitute removed sections 8, 10, 11 from the bill. These sections were addressed in other legislation. And I do have a couple witnesses here. I think James Quintero from TPPF and the ever-present Ed Johnson.
Thank you, Senator Betancourt. Senators, any questions for the author on 2044? Senator Birdwell, you're recognized.
Thank you, Mr. Chairman. You mentioned that there was a bill that had done some other things that you took out. You may be referring to what we did with my bill about a month ago that you signed on to. So
Right.
my question is does this replace my bills?
No.
Does this supplement it? Do ours act in conjunction together? Or if the governor signed mine last, does mine become effective? And I'm just trying to...
Well, I believe this has a broader, okay.
It does. There are
right, a broader
things you did in here that I didn't
Right.
cover. So
Right, and we're later in the process, so I think, you'll get to second base and we'll hopefully get you home at the same time I do. But no, I appreciate the support on this, Senator Burwell, because the stories I can go into them, Chairman, but
yeah.
they're just preposterously stupid. No offense to the school districts involved in this. I'm appalled by the electioneering that occurred, just appalled. And why don't we take some testimony and get the bill on
I just didn't know if they're moving in conjunction together or is there,
We'll double
will
check.
one become the superseding bill of the other?
I think they're complementary.
I think so, but I
right,
just,
but we'll double check.
okay, yes, sir. Thank you, Mr.
And
Chairman.
We already passed another bill that had sections 8, 10, and 11 in it on a different subject.
Right. It's also possible that something could get hung up over there and one of ours gets to the governor and the other one doesn't, and
As you and I are prone to belt and suspenders.
yes, sir, hoo-ah. Thank you. Thank you, Mr. Chairman. Thank you, Senator.
Thank you, Senators. We'll open testimony on Senate Bill 2044. The chair calls James Quintero and Ed Johnson. Mr. Quintero, Mr. Johnson are the only witnesses we have registered as wishing to testify on, for, or against Senate Bill 2044. Public testimony is open. If anyone else wishes to testify on, for, or against Senate Bill 2044, please make your way to the table. Mr. Quintero, welcome back. Introduce yourself when you get situated there and give us your testimony.
Yes, sir. Mr. Chairman, members of the committee, my name is James Quintero. I represent the Texas Public Policy Foundation. I want to thank you for the opportunity to address the committee today on this critical election integrity measure. I'm here to testify in support of SB 2044. Under current law, Texas governments are prohibited from using public resources to influence election outcomes. And yet, today, school districts seem emboldened to bend or break the law for the purpose of winning passage of a bond, promoting a candidate, or getting a tax hike across the finish line. Examples of this type of troubling activity are plentiful. There are, of course, the 7 school districts which were sued by the Attorney General last year, and those cases are summarized in pages 12 through 14 of your report. A few years prior to those instances, though, the AG actually sent cease and desist letters to 5 districts, Brazosport, Elgin, Galena, Holiday, and Louisville ISDs, over electioneering concerns as well. Independently of the AG's office, still other ISDs have found themselves in the media spotlight over alleged bad behavior. Things like South San ISD busing employees to the poll, Midland ISD instructing teachers to send kids home with pro-bond promotional materials, Richardson ISD going door to deliver materials containing the phrase, "Help get the Democratic voting info out." Belton ISD superintendent emailed all principals urging them to make a strong push with staff and parents during a bond election. And then perhaps the most egregious one in my mind is Northside ISD's admin telling staff point blank, "Thank you for supporting the NISD Bond 2022. As per Dr. Woods, all employees will be expected to vote for this year's bond. Central office will be monitoring campus percentages for employee voting stats in the next weeks to come and will be expecting all employees to vote." These examples and others illustrate the need for strong new laws that make it clear schools are for learning, not for politicking. For this reason, I want to encourage the body today to consider passing SB 2044. Thank you for your time.
Thanks, Mr. Quintero. Senator Betancourt, you're recognized.
Just a quick follow-up. There's been an explosion of this activity.
Yes, sir.
And we've seen it in political primaries. We have seen it in TRE elections. We've seen it in general elections. There's an election, I'm not sure what elections we haven't seen it in at this point. You know, the level of electioneering has just gotten to the point of, it's a sad state of affairs when the school districts have either have turned themselves into electioneering arms. And I've been a complainant on many of these original investigations just because it's so appalling. Am I missing something here, James?
I think you were spot on, sir. Unfortunately, I wish that I could point to one single factor that was prompting school districts to act in this way, but I think it's a multifaceted problem. My hope is that when we add teeth to the laws, it will provide enough of a disincentive that they'll start behaving in better fashion.
I hope so too, because whether it's Senator Birdwell's bill that goes first or Frick or Frack's bill that passes, this needs to stop. Thank you for your time and consideration, Mr. Chairman and members.
Thank you, Senator Bardwell. Members, any other questions for Mr. Quintero? Very well, thanks for being here. You're excused. Still looking for Ed Johnson. Chair calls Ed Johnson and anyone else. Is there anyone else wishing to testify on, for, or against Senate Bill 2044? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair now lays out Senate Bill 2819, and recognizes its author, Senator Bettencourt, to explain the measure.
Thank you, Mr. Chairman and members. Under current law, county elections administrators are prohibited from being a candidate for public office, holding a public office, holding an office or position within a political party, and it is a misdemeanor for them to make political contributions or expenditures, support or oppose a candidate for public office. If convicted, their employment is terminated, and they are ineligible for future appointment as a county elections administrator. As serious as these restrictions are, however, concerns have been raised that election administrators may still be appointed to an office or position by an elected official, creating a potential conflict of interest. Senate Bill 2819 addresses this issue by prohibiting county elections administrators from holding an office or position appointed by an elected official. Pretty self-explanatory. Be happy to answer any questions.
Thank you, Senator Bettencourt. Members, any questions for the author on 2819, Senate Bill? Very well, we'll open public testimony. The chair calls Ed Johnson. And Ed is the only witness who registered to testify on, for, or against. Public testimony is open. Is there anyone else wishing to testify on, for, or against Senate Bill 2819? Seeing none, hearing none, public testimony is closed. Bill's left pending this time. The chair now lays out Senate Bill 2403 and recognizes its author, our colleague Senator Middleton, to explain the measure.
Thank you, Mr. Chairman. Members, this is the Texas Ethics Commission Sunset Bill, product of all the interim hearings that we had with the Sunset Commission. The Texas Ethics Commission was created to safeguard the public's trust in government, to ensure that elected officials, candidates, and lobbyists operate under clear ethical standards and transparent reporting rules, but a system that punishes minor mistakes while allowing serious misconduct to slip through the cracks causes it to fail in its core mission. Those are a couple of things that came up during Sunset. Right now, the complaint process is too often arbitrary, opaque, and unbalanced. Public servants can be dragged through drawn-out investigations over clerical errors, while major violations can sit unexamined for months. The process has become more about checking boxes than delivering accountability. Worse still, professional lobbyists, sometimes funded with tax dollars, have learned how to obscure their influence. Vague disclosures, delayed filings, and a lack of legislative specificity means the public often has no idea who's pushing policies at the Capitol. Reforming the Ethics Commission is not just about updating the rules, it's about restoring credibility to a system that is supposed to be impartial and principled. Texans need to know that when someone breaks ethics laws, the response will be measured, timely, and just, and they deserve a government that values transparency, not just in theory, but in practice. Senate Bill 2403 is about putting integrity back at the center of the Ethics Commission's enforcement. It's about prioritizing real misconduct over technical infractions, ending the weaponization of the complaint process, and shining a light where dark corners have persisted for too long. The bill reflects the simple principle that in Texas, ethics enforcement should be fair, focused, and above all, accountable to the people that it serves. The committee sub, so we have a committee sub to lay out.
Senator Middleton is up to the committee substitute and is recognized to explain it.
Thank you, Mr. Chairman. Members, the committee substitute Senate Bill 2403 builds on the original bill's intent to reform the commission, but introduces several key changes to improve the structure, enforcement prioritization, and procedural fairness. Unlike the original version, which broadly aims to update enforcement practices, the substitute creates a formal three-tier system, and this is in working with Sunset staff and the commission itself in creating this three-tier system for categorizing violations. Category 1, which is technical, minor things. Category 2, which is everything that's not Category 1 or 3, and Category 2 is the standard. Category 3 is serious violations. It directs the commission to adopt a written risk-based policy for prioritizing complaints, a framework absent in the original bill. The substitute also restructures preliminary review hearings by requiring bipartisan panels, expands the respondent's response window from 10 to 30 days, and allows the State Office of Administrative Hearings to conduct formal hearings when requested. In contrast to the original bill's more general reforms, the substitute enhances procedural protections and administrative transparency. It also authorizes the Commission to dismiss low-level complaints early, a provision not included in the introduced version. It also adds new requirements for public notice, including publishing categorization policies and penalty schedules online, and soliciting public comment before making substantive rule changes. Overall, the committee substitute retains the original bill's core reforms while adding more detailed structures for fairness, accountability, and efficient case management. And we do have some amendments.
Thank you, Senator. Senator Schwartz, you're recognized.
Yes, thank you, Mr. Chairman. And Senator Mays, I appreciate all your work on Sunset. I wanted to bring this up because I know as with this bill moves forward, if it's not brought up in committee, you cannot bring it up on the floor. But when it comes to the categorization of violations, right now there are two categories, and there's a problem with the delineation of violations into these two categories. And so the solution, at least from my understanding that's being proposed in this bill, is to introduce a new category called Category 3, which means on page 9, a serious violation of law within the jurisdiction of the Commission. In Category 1, members, is just a technical or de minimis. Category 2 is everything that's not a 1 or a 3. So we're adding a new category to solve a problem with the other two categories, and it seems to be a bit of a bit much, I guess would be. And I was considering talking to you and working through the idea of removing this Category 3 violation and further clarifying Category 1 and 2 to make it maybe a little bit easier to administer. I'm not sure where you are on that, but I wanted to bring it up in the committee and seek the advice of the committee members and testimony.
And that's an issue that we've addressed, in Sunset. The issue now is there's two categories. And if you're not the de minimis, the minor violations in Category 1, you just get thrown into Category 2. And a lot was getting thrown into Category 2, which was a problem. So the intent of this is to separate it out. And I'll have an amendment on Category 1 to create a process where someone makes an innocent mistake, it'll be dismissed. Because we heard about, grassroots activists, individuals that, they're not professional lobbyists, they're not, elected officials. They're just, they care about a particular issue, and then they get a complaint filed against them. And they basically have no way to defend themselves. They can't afford lawyers. So I do have an amendment that creates a mandatory dismissal of that Category 1, but because we're doing that, it pushes some of those more serious things out of Category 1, or that used to be classified Category 1, and Category 2, and it creates a need, I think, for Category 3. And there is an outline here in how that has to go about in 571-1213. It's the dollar amount of the violation, the timing of the report relative to an election, the penalty of any criminal offense associated, a potential violation that has concealment of evidence or distorting of public disclosure, in other words, lying on government documents. So I do think there is a need, since we're addressing Category 1 in this substitute and also with an amendment, to shift the most serious violations to their own category, which of course we're going to have open meetings on that and a formal rulemaking process that's part of this bill as well. So I think that separation is needed. I think that there are very few that would fall in Category 3. But right now, almost everything is the way the law is now, is falling into Category 2.
Right. I appreciate your discussion. It's just, again, Category 3 is defined as a serious violation of law within the jurisdiction of the Commission. There's some arbitrary, I guess, enforcement. What's a 2? What's a 3? We're adding a brand new category. To me, I would think that we would be wanting to go the opposite way regarding the overall power of the TEC based upon the various concerns you just said regarding overzealous aspects of de minimis infractions. So just the idea. Well, I look forward to hearing the testimony and is this what you were discussing, that the definition of serious there of Category 3 violations, is that defined somewhere in the bill? I'm sorry, you were giving some verbiage.
Yeah, so I was talking about how that's determined. So that's in the section after, and it's how they determine
The categorization of violations
Yes,
section?
yeah. It's in the section just below that. So there's a long list of, how that is to be determined, whether it's categorized as a serious violation or not, and various factors that have to be considered.
So they'll have an obligation and a task to define the various infractions into these categories once
Right.
this were to pass.
And a lot of that came from, the Sunset Commission meetings where everyone's kind of all lumped in as one, and some are really bad actors, and some are just innocent mistakes by,
Right.
Individuals that, put out a yard sign. There was one lady, I think she put out a yard sign about something in the neighborhood, a community center or something, and she ended up getting fined. That's
just,
kind of stuff we don't want.
In general, I just would like to see better, I guess, evaluation of the infractions and de minimis ones being removed and adjudicated in a way that really is in the best interest of the people of Texas. And then I'm having just one or two categories and appropriately managing it. But having a third category, y'all decided to do that in Sunset, so I respect it. I just wanted to bring it up as a further point of discussion amongst the committee and hearing testimony.
Thank you, Chairman.
Yeah, thank you, Senator Schwartner. Senators, is there any other questions for the author on 2403?
Yeah.
Since this is a sunset bill, it is the Senate practice for any amendments to be considered on the floor to be offered in committee first. And so I believe the best way is for us to go through the proposed amendments here, but not adopt them at this time, but they'll be offered. And then the amendments that are determined to be germane and that the committee likes can be rolled into a new committee substitute. If there's no objection, I'll recognize Senator Middleton on amendment number 1.
Thank you. Thank you, Mr. Chairman. Members, so Amendment 1 requires lobbyists to include specific bill numbers or administrative cases in their registration if available, if a bill number is available, and update their registration if that information changes. The goal is to make it easier for the public to see exactly which legislation or issues lobbyists are trying to influence.
Senators, is there any questions for the author on amendment number 1?
And then withdrawn.
Very well, if there are no questions, amendment number 1 is withdrawn. And the Senator Middleton's up committee amendment number 2. And the chair recognizes Senator Middleton on committee amendment number 2.
Thank you, Mr. Chairman. Members, Amendment 2 prohibits lobbyists who are registered on behalf of a statewide association representing political subdivisions of the state from taking on additional clients. This is intended to prevent conflicts of interest and ensure that those lobbying for local government associations are not also representing other interests at the same time.
Members, any questions on amendment number 2? Very well, amendment number 2 is withdrawn. And Senator Middleton's up committee. Senator Middleton sends up committee amendment number 3, and he is recognized to explain it.
Thank you, Mr. Chairman. Members, This is one you've seen before. This is the as voted out of this committee. So as it was voted out of this committee, the committee substitute to Senate Bill 19. That's what this is.
Members,
Which
any
is the
questions?
ban on taxpayer-funded lobbying.
I'm sorry, I cut you off. Go ahead, Senator.
Which was the ban on taxpayer-funded lobbying.
Members, any questions on amendment number 3? Amendment number 3 is withdrawn, and Senator Middleton sends up committee amendment number 4, and he is recognized to explain the amendment number 4.
Thank you. Thank you, Mr. Chairman, members. It's a transparency amendment. It requires that on your local tax bill, that the taxing unit disclose on that bill how much was spent during that tax year to compensate or reimburse someone that is required to register as a lobbyist to influence legislative, executive, or other form of administrative action.
Thank you,
it's a
Senator. Members,
disclosure bill.
any questions on amendment number 4? Very well, amendment number 4 is withdrawn, and Senator Middleton sends up amendment number 5 and is recognized to explain committee amendment number 5.
Thank you, Mr. Chairman, members. Amendment number 5 gives respondents the option to request that formal hearings on ethics complaints be conducted by SOA, the State Office on Administrative Hearings, instead of the Ethics Commission itself. So this provides some independence, I think, that is needed. If a respondent makes this request, they must cover the associated hearing costs as determined by the administrative law judge. The amendment ensures that the cost recovery for SOA ensures cost recovery for SOA while adding a layer of procedural flexibility and impartiality for respondents.
Thank you, Senator. Members, any questions on amendment number 5? Very well, amendment number 5 is withdrawn, and Senator Middleton sends up amendment number 6, committee amendment number 6. I think it's clear these are all committee amendments. Number 6, and recognizes Senator Middleton to explain the amendment.
So this is the amendment I discussed earlier with Chairman Schwartner. Amendment 6 allows the Ethics Commission to dismiss Category 1 complaints at any stage if the violation is minor and not worth further commission resources or consideration. It also requires automatic dismissal if the respondent has 2 or fewer prior Category 1 complaints and the violation is considered low risk. So this helps those that have essentially gotten caught up in the system. We heard about in the Sunset Commission several times about individuals that had large fines for very minor violations, de minimis violations. So this allows a formal process to dismiss those.
Any questions for the author on amendment number 6? Amendment number 6 is withdrawn, and Senator Middleton sends up amendment number 7 and is recognized to explain committee amendment number 7.
Thank you, Mr. Chairman, members. This is a different version of amendment number 3 that we heard earlier. This amendment expands lobbying restrictions to bar registrants from lobbying on behalf of political subdivisions of the state or an association that primarily represents political subdivisions of the state.
Members, any questions on committee amendment number 7? Very well. Amendment number 7 is withdrawn. Senator Birdwell sends up committee amendment number 8 and is recognized to explain committee amendment number 8.
Thank you, Mr. Chairman. Members, 2019, the legislature passed HB 2677, which restricted former members of the legislature from engaging in activities that require them to register as lobbyists if they had made a political contribution using campaign funds in the previous 2 years. The law was meant to prevent a situation where, for example, a lawmaker disperses his campaign funds from his campaign and contributes those to previous or current colleagues, and then steps down or loses re-election, and then goes to lobby those same colleagues a short time later. In 2023, the Texas Ethics Commission issued an opinion that a former member registered to lobby could face fines of $5,000 or triple the amount at issue for a violation of the law. The problem with that opinion was that it left the amount at issue undefined at the time of the opinion, but left it to their own discretion, which could result in exorbitant fines. Meaning that, as an example, you could have somebody that made donations that were less than $5,000, but the totality of their campaign account would be the question at issue because the check came from their campaign account. So what my amendment does is it codifies in statute a maximum threshold on the civil penalty to twice the amount of the contribution or expenditure if a former member utilizes their campaign account for political donations during the 2-year moratorium. That way you don't have what happened to the previous member where they made 3 donations totaling $5,000 with a fine of $150,000 because they said it was the totality of their account from which they wrote the $5,000 checks. Similar to what you said earlier, Senator Middleton, about exorbitant fines, not correlating to the de minimis, the act. So members, I've also filed this legislation, Senate Bill 2781. It's in amendment format here. I believe we're actually going to hear the bill, but at this point, I'll pull out an amendment and hope for, as another vehicle to make sure both get there. I appreciate your consideration, Senator. Thank you for your hard work on Sunset. Both Senator Shortner and I have chaired it, and I know the difficult scheduling and all that. So thank you for the work on this issue.
Thank you, Senator Birdwell. Members, any questions for Senator Birdwell on amendment number 8? Very well. Amendment number 8 is withdrawn. We'll now open public testimony on Senate Bill 2403, and the chair calls Ken Moore. Ken is the only witness who has expressed a desire to testify. Is there anyone here? Public testimony is open. Anyone else wishing to testify on, for, or against Senate Bill 2403? Seeing and hearing none, public testimony is closed. Senate Bill 2403 be left pending at this time.
Which one? Chair lays out Senate Bill 2337 and recognizes Senator Hughes on his bill.
Thank you, Mr. Chairman. Senate Bill 2337 is about proxy advisors and about proxy advisor transparency. Proxy advising firms or advisory firms are something that many of us had not heard of, though I should assume most folks are more sophisticated than I am, but something I had not heard of until the last few years. Proxy advisory firms provide services to corporations and institutional investors. An institutional investor, for example, a pension fund, an endowment, they may be invested in hundreds or even thousands of companies. And for each of those companies in which they own shares, they have proxies, they have votes at the company's annual meeting. And they don't have the time to do all the research necessary on matters that arise for a shareholder vote with each company they invest in. And so they rely on what they thought were experts to satisfy their fiduciary duty to shareholders. And they hire one of primarily two proxy advisory firms. There's really only two that have the majority of about 95% of the market. And these firms are supposed to do the research for you and make voting recommendations. Historically, proxy advising firms have given advice on whether the companies are good corporate citizens, corporate hygiene, are they complying with the law, with SEC rulings, looking at SEC circulars, et cetera. Sadly, in recent years, proxy advisory firms have become increasingly political and with a hard left bent. Both of these companies, the two primary proxy advisory firms that control 95% of the market, are foreign control, one by German and one by Canadian interests. And this means the current landscape in which two foreign proxy advisory firms have an outsized influence on the overall success of Texas companies and the boardrooms that lead them. Recent evidence has shown that these and other proxy firms are basing their advice to clients on factors other than maximizing shareholder returns. Some are basing their advice on ESG standards, other times on DEI priorities. And this is actually the cases where a single proxy advising firm has given two or more of its investor clients, has given irreconcilable advice to two or more clients on the same proposal. So proxy advising firm X represents two different companies, and on the same vote, it gives those two companies differing advice, recommending sometimes both for and against the same company proposal, or a director nomination, or a merger or acquisition, or an activist shareholder proposal to divest from certain investments. All of this while knowing that each of those clients they're advising has a fiduciary duty to its stockholders to maximize financial return. And the proxy advisory firms justify their own subjective and often irreconcilable advice on the basis that they themselves, here's the key, the proxy advisory firms, they don't owe a fiduciary duty to their clients, or that's their position. We want to make sure that's clear, because the people they are representing do owe that duty. We believe this is fraudulent behavior, and it harms Texas companies, investment firms, and the life savings and investments of the people we represent, hardworking Texans. We have to look out for them. I don't have to lecture this committee about that. We know how important that is. Senate Bill 2337 will highlight these conflicts, and it requires that the proxy advisor firms disclose whether their advice is based on non-economic factors or if they're giving conflicting advice to different clients, which brings these conflicts to light. It's designed to prevent fraud and deceit in this this relatively unknown area where tremendous policy decisions are being made by folks who were never elected and who have never publicly stated positions on so many issues that affect our daily lives. Also provides an enforcement mechanism through the existing Deceptive Trade Practices Act and the Declaratory Judgment Act and the remedies that go along with that. Conflicts are a real problem, and they need to be highlighted and dealt with. Sunshine, like in so many cases here, is the best disinfectant. We have some expert witnesses here who are very knowledgeable about the problems in this area and know what needs to be done to fix it. We do have a committee substitute, Mr. Chairman.
Senator Hughes is the committee substitute for Senate Bill 2337. You're recognized on the substitute.
Thank you, Mr. Chairman. The committee substitute replaces the file version with the legislative council version, and amendments reduce the risk of a preemption filing and litigation and eliminate ambiguity in the initially filed bill. Also adds an attorney general enforcement angle regarding fraudulent and deceptive conduct, which is an exception to the preemption provision in the Investment Advisors Act. Also tweaks some definitions, disclosure requirements to be more objective and fact-based and less onerous. This is not designed to be an unreasonable burden, but it is designed to bring transparency and fairness and sunshine to this process. And with that, I'm happy to yield for questions.
Members, questions? Thank you, Senator. Chair's going to open up public testimony. Chair calls Farrell Keel, Matthew Dumee, Jason Isaac, and Margot Cardwell. Ms. Cardwell, welcome. Please state your name and position, and you may begin when ready.
Mr. Chairman, members of the committee, thank you for the opportunity to appear. My name is Margot Cardwell, testifying on behalf of the Texas Civil Justice League, and we are in support of Senate Bill 2337. TCJL is the nation's oldest and largest state legal reform organization. Our members include corporate businesses of all sizes, many of which are publicly traded, in addition to law firms, professional and trade associations, as well as individuals. Chairman Hughes, I don't think I can improve upon that layout. So I will be quick, but I do want to thank you for highlighting the legal and policy issues attendant with proxy advisory services and for proposing a Texas solution, one that respects the state's role and principles of federalism to bring valuable oversight and transparency to the influence of proxy advisory firms on U.S. boardrooms and shareholder value. For context, more than 70% of the outstanding shares of public U.S. companies is owned by institutional investors who owe a fiduciary duty to the beneficiaries of the investments they manage. When it comes to voting on proposals affecting corporate decision-making, institutional investors account for more than 91% of the voting shares. This outsized influence has given rise to third-party proxy advisory firms. Two such firms account for roughly 97% of the market. While the use of proxy advisors is not in and of itself a bad thing, when the same firm contracts with different subsets of clients and investors in the same company, it makes conflicting recommendations on how to vote on a company proposal. Legitimate questions arise as to how dueling recommendations can simultaneously serve the best financial interest of the company and its shareholders. SB 2337 would address this conflict by imposing a duty of candor to reduce fraud and deceit, by requiring proxy advisors to disclose whether recommendations to investors are based on non-financial factors, and to further give notice when conflicting recommendations are made to different clients with respect to the same proposal. In doing so, Senate Bill 2337 ensures that institutional investors, who unlike proxy advisors do owe a fiduciary duty to shareholders, are fully informed and equipped to execute their obligations faithfully. Thank you again for the opportunity to testify, and I look forward to answering any questions.
Thank you. Mr. Isaac?
Thank you, Mr. Chairman. Chairman Hughes, members of the committee, thank you for the opportunity to be here. I'm Jason Isaac with the American Energy Institute in support of Senate Bill 2337, which brings long overdue transparency and accountability to an industry that has been quietly reshaping corporate America, the proxy advisory firms. Senate Bill 2337 demands that proxy advisors act in the financial interest of shareholders or else disclose that they are not. Imagine that. We have to tell fiduciaries to act in a fiduciary duty, but we do. Make no mistake, these reforms help protect Texas headquartered companies from being railroaded by coordinated political campaigns masquerading as shareholder activism. Please defend free enterprise, transparency, and fiduciary duty and make sure proxy advisors are once again servants of shareholder value, not social engineers. We don't need to speculate about the damage proxy advisors can cause. We have proof right here in Texas. In particular, the University of Texas, Texas A&M Investment Management Company, UTIMCO, which manages tens of billions in public assets, was shown to be aligned with a political voting agenda that not only betrayed Texas energy producers, but also compromised the fiduciary integrity of their investment processes. It's my understanding that UTIMCO is partnered with either ISS or Glass Lewis. The details on their report are available on my Substack. It's titled UTIMCO's Woke Agenda Betrays Texans. I'm happy to provide that to the committee afterwards. But Senate Bill 2337 ensures that proxy advisors cannot quietly steer public and private capital toward ideologically driven goals. If they are offering advice that isn't based solely on maximizing returns, they must say so clearly and publicly. I had the opportunity to testify in front of Congress about a year and a half ago, and at that time it was testifying on this exact same issue about ESG investments and ESG returns. And ESG returns were negative at the time that I testified, compared to the S&P and NASDAQ, which were providing positive returns for investments. And it just shows that investing in political agendas winds up costing taxpayers and investors money. It's not the right thing to do. I urge you to support Senate Bill 2337. Thank you for the opportunity to be here and testify.
Thank you. Farrell Keel?
Keel, yes. Chairman Hughes, members of the committee, thank you so much for having me here. My name is Farrell Keel, and I'm a partner at Jones Day, sitting in our Dallas office. And I focus on securities and corporate governance issues. My statements here are my own, but they are necessarily informed by my experience advising public companies, big and small, and across a wide range of industries. I'm grateful to Senator Hughes for his focus on this issue, which addresses two fundamental and missing elements from the proxy advisory business: accountability and transparency. Tackling accountability first. As I think about the various actors in the proxy process, nearly everyone is held accountable in some shape or form. Boards are held accountable by shareholders. If a company doesn't perform, the directors are ousted. Companies are held accountable by rules and regulations. If they make a material misstatement or omission, both the SEC and shareholders can take action. And as for asset managers, they are held accountable by their performance. If they don't make money, the money will be moved. But for proxy advisors, and specifically ISS and Glass Lewis, I'm scratching my head as to who they are held accountable by. Their advice is not tied to financial performance. In fact, their advice is completely disconnected from the economic impact that it has. While they oftentimes control, say, even 30% of a company's votes, they have no skin in the game, and therefore their interests are not aligned with the real shareholders. From a competitive perspective, given they control approximately 97% of the advisory business, there is no competition to keep them in check. And from a regulatory perspective, there is very little oversight. So this now takes me to the second element that I mentioned, transparency. In 2020, the SEC put forth a rule to clarify that proxy advice is a, quote, solicitation. This would mean that their advice would be subject to the very same anti-fraud provisions that companies and other actors who participate in the proxy solicitation and system must abide by. In sum, solicitations may not contain false or misleading statements. That's not a high bar. This rule led to an all-out brawl in the courtroom as ISS fought it tooth and nail. To me, it is ironic that these institutions who purport to define good governance bristle so strongly at the idea of holding themselves to the same anti-fraud standards as the companies that they evaluate. Proxy voting advice is admittedly a tricky issue. Asset managers are faced with thousands of proposals a year that address nuanced issues, and I'm sympathetic to the need to enlist assistance to make these decisions. However, as we see the trend toward passive investing grow and asset managers become increasingly reliant on proxy advisors, their influence is amplified and it is unchecked. One would hope that the entities with this power and influence would have a narrow focus on the singular thing that most investors prioritize, value creation. Alas, the proxy advisors have strayed from this concept by prioritizing agendas where the nexus between their guidance and the financial well-being of a company is far from clear. Proxy advisors' lack of focus on long-term value creation is not the only reason that oversight is necessary. There are a lot more reasons. First, they operate in the shadows. Neither ISS nor Glass Lewis fully disclose the methodologies that they use to develop their voting recommendations. As a result, it's impossible to tell what is driving those recommendations. Second, their recommendations often contain inaccuracies that are difficult to correct in the marketplace and can be misleading to the very investors that they seek to serve. When I was a first-year lawyer, one of my very first tasks was to review and confirm the accuracy of an ISS report. After finding multiple mistakes, I figured I must be the one who didn't understand what was going on, because how could something so polished with so much authority possibly be wrong? Third, for entities who purport to be the arbiter of good governance, they sure do have a lot of conflicts of interest. For ISS, they conveniently provide consulting services to companies who need their support. And what does this actually mean? Boiled down, it means that companies have to pay for votes. And ISS has an economic incentive to make its policies opaque and complex and to change them frequently to increase demand for its own consulting services. For Glass Lewis, companies have no idea what Glass Lewis is saying about them unless they pay for it. And to paraphrase a small cap Texas public company, they said, "It ain't cheap." And in any other scenario where someone is influencing a shareholder vote, they would be required to provide full transparency, and yet Glass Lewis is accountable to no one. Fourth, their recommendations can be illogical. This is my favorite. I'll get through it fast. So this is a real-life example. ISS and Glass Lewis, as background, they express a preference that have a certain number of women on a board. If you do not meet their standard, they have historically voted against the director in charge of your nominations as a punishment. What happens, though, when that director is a woman? Well, Glass Lewis will tell the shareholders to vote against a woman because there aren't enough women. I'll pause to let that sink in. It doesn't make sense. So in sum, oversight of the proxy advisors is long overdue, and well-crafted legislation can provide predictability to companies and create the accountability and transparency that shareholders deserve, furthering the very mission that proxy advisors purport to pursue.
Thank you.
Thank you for having me.
Mr. Demey?
Thank you, Mr. Chair, members of the committee. My name is Matthew Dumais. I work with Fusion Law, and I'm here on behalf of Heritage Action for America. Proxy advisors are the third prong of a three-pronged attack by ESG activists. Asset managers and banks have recently beat a little bit of a retreat, at least publicly, on their ESG commitments, but proxy advisors continue to push an ESG agenda, and many of their clients blindly follow those recommendations. In my testimony today, I'll focus on ISS and Glass Lewis, because even though there are other proxy advisors that are of concern, these two can swing an estimated 30% of a shareholder vote. Both of these proxy advisors are foreign-controlled and claim that they are making recommendations to their clients based on shareholder value. However, ISS and Glass Lewis frequently make recommendations that appear to be based on ESG or DEI, not on shareholder value. For example, in 2023, both recommended in favor of a proposal to force Boeing to report on whether Boeing's lobbying aligned with net zero emissions goals. But net zero goals call for dramatic demand management to decrease and cap air travel, which obviously would hurt Boeing and its shareholders. Similar efforts are targeted at Texas companies on a regular basis, particularly energy-related companies. And to tie back to the insurance issue, which was mentioned earlier, ISS and Glass Lewis also supported a proposal asking Berkshire Hathaway to report on if and how Berkshire intends to reduce emissions from its underwriting and insuring activities in alignment with the Paris Agreement's goal. Now, the House Committee on the Judiciary has alleged that ISS and Glass Lewis are a foreign-owned duopoly that conspired with a climate cartel. Notably, the committee also stated that both advisors appear to have leveraged their influence in the proxy advisory market to pressure U.S. companies to buy their affiliated corporate consulting services. That represents a clear conflict of interest. State attorneys general have repeatedly expressed their concern over these proxy advisors, including concerns about these advisors potentially giving misleading advice to their clients. In 2023, Texas and Utah co-led a letter signed by 21 state attorneys general in which they wrote to ISS and Glass Lewis and expressed their concerns that the proxy advisors had promoted and relied upon false and misleading statements implicating state deceptive trade practices laws. And in 2024, state AGs, including Texas, wrote to asset managers that followed ISS's 4 recommendations over 75% of the time on ESG proposals that were flagged by the activist group series. Last month, the Florida Attorney General opened an investigation into ISS and Glass Lewis regarding potential misrepresentations related to ESG and DEI. SB 2337 would add much-needed transparency and sunlight to the proxy advisory process. It would require proxy advisors to notify their client when they are giving conflicting advice, or when they are recommending a vote that is not solely in the financial interest of shareholders. If proxy advisors are issuing recommendations based on non-financial considerations, whether that be ESG, DEI, their consulting business, or their foreign owners, proxy advisors should be required to disclose that information to their clients so that their clients can make informed decisions. The required disclosures would also help prevent blind reliance on these recommendations by financial institutions. It's difficult to ignore the reality that a recommendation is driven by ESG or DEI when your proxy advisor specifically tells you that this recommendation is not solely in your shareholder client's financial interests. Without that information, there's willful blindness or worse that's occurring and negatively impacting Texas businesses. Thank you for your time.
Thank you. Members, questions of this panel? Thank you. Y'all are excused. Chair calls Jack McFerrin, Will Hild. Anyone else wish to testify on, for, or against this bill, please come forward. Welcome, Ms. McFerrin. Please state your name, position. You have 2 minutes.
Mr. Chairman, members of the committee, thank you for inviting me to speak. My name is Jack McFerrin. I'm a research fellow with Heartland Impact, and I am for this bill. SB 2337 mandates proxy advisory services based in Texas to provide recommendations solely based on the financial interests of shareholders and exclude non-financial considerations like ESG. This is crucial because proxy advisors are a really important and undiscussed piece of the ESG puzzle. Usually a lot of the discussion of the investment advisory is focused on the big 3 asset managers and not enough about ISS and Glass Lewis, like other witnesses talked about, is mentioned. and some of this has already been mentioned, but ISS and Glass Lewis together control approximately 97% of the proxy advisory market. There are some other estimates, but that's the one that I have found. These firms issue ESG-driven voting recommendations to institutional investors, including pension funds, mutual funds, and asset managers that are often followed without question. For instance, a review from the Harvard Law School Forum on Corporate Governance found that proxy advisors such as ISS and Glass Lewis can swing between 10% and 30% of shareholder votes. Another study by the American Council for Capital Formation found that 175 asset managers controlling more than $5 trillion in assets voted in accordance with the recommendations of ISS more than 95% of the time. They're also involved in board takeovers along with the big three asset managers such as ExxonMobil in 2021, as well as Chevron. So passing this bill would help negate that influence and ensure proxy advisors provide recommendations that align with Texas law and the objective interests of objective financial interests of shareholders. Thank you.
Thank you. Mr. Hill?
Yes, and given the time of night and the number of witnesses, I'll be mercifully brief here. I just want to point out one additional thing that was not pointed out. This relates to both this bill and what we spoke about before with ESG and insurance. One of the proposals that ISS and Glass Lewis previously recommended was to force Travelers Company, that'd be Travelers Insurance, to report on if and how it intends to measure, disclose, and reduce the GHG emissions associated with its underwriting, insuring, investment activities, in alignment with the Paris Agreement. So that gets right to the core of the matter there, where you have out-of-control proxy advisors trying to co-opt insurers into a cartel against the public. And so that's why oversight by the state of Texas in this bill is so important. And I would just add that proxy advisors came about, actually, one of the co-founders of ISS was a guy named Robert Monks. He served in the Reagan administration and was responsible for interpretation of the regulations at that point that basically created the need for proxy advisors. And then he quickly left after a year in the Reagan administration to go start one, which was very advantageous for him. And basically what that created, this is not an unlimited safe harbor provision, but it created a limited safe harbor provision for asset managers who have a fiduciary responsibility to vote their shares. They could basically offload that to proxy advisors, and they would not be as responsible, except in very egregious cases, for whether those votes were actually in line with the fiduciary duty they owed to their own clients. So basically it was a cheap and easy way for them to get out of the way of this. And the problem is, if asset managers have a fiduciary responsibility to their shareholders to vote correctly, but then they're able to offload it to companies that don't have the same fiduciary, or at least it's not being enforced against them properly, that basically is a complete abrogation and breakdown in consumer protection, and as we've seen, a protection of corporate America, making sure that they have their eye on the ball to focus on returns for shareholders and not far-left political objectives. So I'll stop there.
Thank you all. Members, questions? Thank you all. Y'all are excused. Chair closes public testimony and leaves Senate Bill 2337 pending. Chair lays out Senate Bill 312 and recognizes Senator Hughes on his bill.
Thank you, Mr. Chairman, and thank you, committee, for working with us here. Senate Bill 312. This bill is of a piece with the bills we've considered this evening on this topic of so-called ESG and what that's come to mean. We know that social and political change in America normally comes through the political process. We elect representatives. When enough people agree there's a problem, we address it. In this process, I want to note this, I've been reminded of this process is purposefully deliberate and at times difficult. Over the last decade or so, frustrated by a lack of satisfactory progress in government, left-wing groups of so-called shareholder activists in Europe and now in this country have begun to instigate change by other means, through corporations. Groups of activists have been very organized in orchestrating these efforts, and they give them, these groups have opaque alphabet soup names, and they work behind the scenes through corporate governance mechanisms that are unfamiliar to regular people who are just trying to save for their retirement. As far as public pensions, the goal should always be return on investment, not social activism. We want retirees to have the most money possible for retirement. And activists target these public pensions. Why? Because of the size of the pension funds and the fact that they subject third-party management. In other words, most people don't manage their own pension funds. A government employee manages all the funds on behalf of the state. And when you overlay that with the previously discussed proxy advisory firms, the concerns and the opportunities for mischief and for doing wrong are just multiplied. And we understand the basic concept of the ESG mechanism. Your 401k that you have yourself, or your pension fund operated by the state, or the university endowment fund, all these institutional investors, they invest their money with a firm like BlackRock, like State Street. BlackRock, State Street, and Vanguard control a tremendous amount of wealth. And of course, those financial firms take your money and they buy shares. Under U.S. securities law, even though they're purchased with your money, those shares belong, the voting rights to those shares belong to those financial firms. So they can control thousands or millions of shares in a company. And so, before the annual meeting, before all the votes that'll be coming up, they can go see the management of the company. And they're not unlike Al Capone and his guys in Chicago back in the 1920s, who would come to a business owner and say, "This is a nice store you have. I'd hate for it to burn down. We can help you with that if you'll just do this, just pay us for protection." So what happens? These firms that control millions of shares, bought with other people's money, they go to these companies and they say, "We'd like you to make these changes. We'd like you to change these policies. If you don't, we have millions of shares we're going to be voting at the annual meeting. So if you like your job, if you like your board, if you like control of your company, you'll do what we ask." And many times they describe these as this with very soft and flowery terms, Mr. Chairman. That's exact. We heard this before. We've heard this testimony. Sometimes they call this engagement. That's a nice way to say it. Many times they get their changes made behind closed doors without anyone seeing it. Other times they actually show up at the meeting and they take the votes and they vote against the board members. They vote against the management of the company, not based on financial returns, based on a narrow political agenda. And in particular, Senate Bill 13, which our colleague, Senator Birdwell, championed, told those companies, if you're going to target oil and gas, you're going to punish oil and gas, you are trying to cut off the lifeblood of the Texas economy. Not just those reliable, high-paying jobs, but that low-cost energy that we rely on for our lives. And especially working folks and working families need cheap, reliable energy. It affects the price of every product we buy. And so, Senate Bill 13, which begun this fight against ESG in America, it said, you boycott oil and gas, Texas boycotts you. So we told these woke banks and financial firms, if you try to cut off funding to Texas Energy, you will pay a price. No pension work for you, no bond work for you in Texas. That bill sparked something across this country where red states are pushing back against these firms and saying, no, you will not politicize our economy. You will not take our money and vote it against our interests. These issues are well known to this committee, but a lot of folks haven't heard about what's been happening. The good news is we're making some progress, and some of the worst offenders are not as bad offenders as they used to be. And so that's part of what's addressed in Senate Bill 312. And I'll just say, based on the vote that this committee took earlier, the firm BlackRock's gotten a lot of attention. And BlackRock has made some changes in the way they vote, which we're thankful for. They've come to Texas and worked to help with dispatchable energy, which we're thankful for. They're working on the Texas Stock Exchange. They're doing some things to help Texas, and we're thankful for that. We invited them to come here and talk about those things. And in case there's any doubt, for months we worked with them about scheduling this appearance. The hearing on these bills would have happened months ago, but we delayed the hearing to get a date when they could come testify. And then at the 11th hour, 2 days ago, we were told for the first time, well, we're not going to come based on pending litigation. Now, we don't know how long that litigation's been pending or what it is, but we know that for months we worked with them on scheduling an appearance before this committee. If anybody has questions about that, I don't think that's in dispute. And so here we are hearing this bill in plenty of time to get it all the way through the process. These delays will not will not stop Texas from defending her citizens and her economy. And so for BlackRock and for State Street, they were invited to be here and cited for the first time litigation is a reason to not come. And of course, we understand that, and sometimes if there's pending litigation, a witness before a committee might have to be careful what questions they answer, how they answer. They might even ask to limit the scope of their testimony. And of course, we work with witnesses to do that. But when we're talking about financial firms that have Texas as a client, firms that are reaping tons and tons of Texas dollars, they will not be allowed to refuse to come and give account for their actions before this committee. It's not about me or us. This is about the state of Texas. And that's why this committee voted earlier to authorize subpoenas against those two firms. We hope they'll work with us. We hope they'll appear. We hope they'll answer our questions. And again, there are many things they can talk about that they're doing well and doing better. But this discussion needs to be had. This discussion needs to be had. And so it will happen one way or the other. And so there's more we could say about the bill, but those are the broad outlines. There's a committee substitute, Mr. Chairman, that we'd like to send up.
Senator Hughes sends up the committee substitute for Senate Bill 312, and you're recognized on the difference between the substitute and bill filed.
Thank you, Mr. Chairman. Activists frequently invoke various types of risk to justify pursuing non-financial goals using public funds. They'll take their left-wing agenda and couch it in terms of, oh, this is in our best financial interest to do this silly, crazy left-wing idea. They'll try to describe it as if it's going to actually make money for stockholders. Now, the record bears out otherwise, but that's what they often say. And so the committee substitute removes general language about risk and requires public retirement systems to focus exclusively on providing financial benefits, an analysis which necessarily involves consideration of financial risk. Again, if we're talking about Texas public pension systems, surely everyone agrees. I know we do in this room. We want them to focus on maximizing returns for our retirees. That's who we work for. That's who they work for. And they obviously have to be reminded of that from time to time. So definitions like that are clarified in the definition in the committee substitute. Some reporting requirements are modified. I'm happy to go into detail, but that's what the substitute does, and I'll yield for questions.
Thank you, Senator. Members' questions of the author? Hearing none, chair opens up public testimony. There are two invited witnesses, Steve Gassenberger and Will Hild. Mr. Hild, please state your name, position on the bill, and begin.
Certainly. My name is William Hild. I'm the Executive Director of Consumers Research, and I am here to strongly support the passage of this bill. I'm so glad that Texas has taken this up, as many other states have. Texas pioneered, of course, as you noted, the anti-economic discrimination legislation that has now been passed in a number of states. Some of the other states have passed this version of this fiduciary bill, and I think it's fantastic for Texas to really come at this problem with both barrels loaded, because that's what it's going to take. And really what I want to talk about today is dispel two things. One is the perception that I think not just BlackRock, but other asset managers are now trying to put forward, that this problem has been solved, that we've won, or that those who oppose ESG have won. And if you'll allow me, and I know I'm going to get myself in trouble right out of the gate here, but if you allow me to just embarrass slightly a great Texan. There is a famous GIF that people often use when they're talking to each other, and it's the former President G.W. Bush on a carrier at the lead up to the Iraq War, and it's got a big banner behind it that says "Mission Accomplished." And of course, this has kind of become comical because things were not over in Iraq. There's a similar analogy I'd like to use here. Larry Fink and the other woke asset managers are trying to portray that they are standing on the SS ESG with a big banner behind them that says "Mission failed. We lost," right? Because nothing would make them happier than if we were to stop pushing on this issue. And while I agree with you, Senator, absolutely, some of their actions have changed. Those actions and those behaviors have only changed as this state and others, and you guys have led in this, have aggressively engaged in trench warfare, whether through legislation or through litigation, to push them off of those positions. And they have only given up that which became totally untenable. And that includes BlackRock's departure from the net zero asset managers shortly after Attorney General Paxton's leading the lawsuit against them for antitrust activities in the coal market. That includes they're changing some of their shareholder votes to make it less obvious what they're doing to intervene. But I would just like to say that they have only given up that which they have to give up. They are still reportedly members of a number of other groups, like Ceres, for example. I found this particularly comical. There was a recent Wall Street Journal piece which was pretty laughable. It looked like the press release from BlackRock, where the headline said, "The woke era at BlackRock is over." It was a very short piece. It cited only one source for this pretty grandiose claim, and that was the CEO of Ceres, a group that BlackRock is still a member of and ostensibly pays the salary of, to claim that, well, they've lost, they're going home, there's no more of this, and yet they're still a member of Ceres and a number of other groups. So that's dispelled myth number one. The other is that, let me get this because I want to be very careful about how I read this off, because the details of this are extremely important. The other is that there isn't more investigative work to be done by this committee. The hearing that you all held in Tyler, Texas, I have been told by numerous people described as legendary. And I kid you not, the groundbreaking work you did investigating during that long hearing, cracking open the ESG cartel with ISS and ISS, BlackRock, and State Street was extremely valuable. And it's a perfect example of the importance of states working in conjunction with the federal government, because not everyone can do everything. And let me point you to an example. I can solve that mystery of why they're not here for you, Senator. It's going to be very interesting today. So an investigation by the U.S. House of Representatives Judiciary Committee has uncovered documents suggesting that BlackRock secretly made commitments to change its voting when it joined Climate Action 100. This contradicts BlackRock's public statements, including express reassurances that BlackRock made to investors at the time. I would substitute investors for made to this committee under oath. The documents also show State Street was pressured to join Climate Action 100 through the threat of losing business. The investigators demonstrated that the effort to force the asset manager to join Climate Action 100 included, quote unquote, the climate cartel threatening BlackRock and State Street Global Advisors to join CA 100, even after both asset managers expressed concerns that the initiative's collusion and collaborative engagement may violate federal law. Now here's the kicker. CA 100 Global Steering Committee meeting minutes that came out during the Judiciary Committee's investigation shortly after BlackRock joined reflect that, quote unquote, BlackRock, this is statements from CA 100 Steering Committee, BlackRock understands that by joining CA 100, it is expected to shift its voting to support climate resolutions. So there you have members of Climate Action 100 saying, BlackRock knows exactly what's expected of them when they join. Well, question is, did they do it? They say they didn't. Let's see. This clandestine commitment is borne out by BlackRock's voting. In 2019 and 2020, BlackRock supported 6% of environmental proposals. In 2021, it supported 64% of such proposals, a 10-fold increase. In 2019 and 2020, BlackRock voted against 55 directors on climate-related issues. But in 2021, it voted against 255, a 5-fold increase from before. This is clear evidence that BlackRock shifted its voting patterns in line with Climate Action 100 committee. So in wrapping up, I would just say, I think that solves the question of why they don't want to come before this committee, Mr. Chairman, because as I recall, 2 years ago when you had then BlackRock Director of External Affairs, Dahlia Blass, in front of you under oath, you asked her about what commitments or what influence Climate Action 100 had over the company and their voting and their corporate engagement. And she told you absolutely none, and that they had sent a letter to Climate Action 100 saying that so I look forward, I'm so glad, I was here to convince you partially to issue the subpoena. I'm so glad to hear those already have been issued, and I look forward with bated breath to their testimony and you asking them whether they stand by those previous statements and whether their responses refer to their Fifth Amendment rights against self-incrimination.
Thank you, sir. Members, questions? Thank you very much.
After the other members, I might have one. I'll wait for the other members, though. Thanks. Are we ready?
Okay, members? Sir.
Yes,
Hey.
thank you for coming today. Good testimony. And I kind of had a follow-up, a little finer point on it where, I'm on the Business Commerce Committee, Chairman Schwartner. We've heard a lot about load growth and future demand, where I think we're supposed to hit maybe 200,000 plus megawatts in demand for Texas in 2031. And, you know, they're seeing that, obviously, BlackRock is, because a lot of that is driven by data centers, which are AI. And you're never going to get there with being able to supply the power for that without natural gas-fired power plant. I mean, nuclear, I hope we can get there. You know, the molten salt reactors are great. I hope we can scale those. I don't think that's going to happen at that scale by 2031. So that really kind of leaves one option. And it goes to some of the things we've heard where they, you know, feel sorry, or they're saying they regret, you know, some of their past behavior in targeting the oil and gas industry. And I'm wondering if you think it's that, or you think that perhaps they see those numbers with the profitability with AI, and that is never going to happen without dispatchable thermal power generation. And so I'm not really convinced that something has changed in their ideology. And I'm wondering if you could maybe speak some more on that.
Yeah, I think that's exactly right. And I think to the extent they are coming into Texas and saying, extending what they are describing as an olive branch of love, we'd love to invest in dispatchable power with thermal sources such as natural gas. These are things that are going to happen anyway. They are trying to act like they are doing Texas a favor for doing what they are supposed to be doing as a matter of fiduciary requirement. This is in line with their strategy from the very beginning of this fight. Our first ad campaigns against them were October of 2021, BlackRockLovesChina.com. And shortly after those campaigns, this Senate and this government was sent a letter from Dahlia Blass at that time. It was a non-public letter, but of course you send it to that many people, it leaks pretty quickly. And they're basically trying to speak out of both sides of their mouth. They claim that, listen, contrary to what you've heard, we don't boycott oil and gas, which of course is absurd. They own like the largest single owner of all these companies. No one, you know, none of the controversy around them is from not owning oil and gas, from what they do with those shares. And so she articulated basically a big red herring. And that was her strategy, and that was their strategy, and that's always been their strategy. So what their strategy is now, to pretend they're MAGA, and I kid you not, they have Charlie Gasparino writing New York op-eds about how Larry Fink is MAGA now, and how he's best friends with Donald Trump, which is absurd, right? So this is totally in line with their strategy from the very beginning. And to your point about the natural gas, you're exactly right. People are going to build natural gas. They're gonna put that in there, and it doesn't take BlackRock to do it. I'm happy for them to do it. I gladly take their terms of surrender and abandon all this nonsense. But you do not, the state does not have any sense of gratitude towards them for doing what anyone is going to do anyway, and what they should have been doing at the beginning.
Yeah, and that's what I was wondering. I mean, it's a profitability thing where, you know, there's a lot of money in AI investment, and you're never going to realize that without the power, you know, continuous, uninterrupted power supply to meet those data center demands, which are huge. You know, I mean, the projection for 2031 is, I think, more than our current and what we can generate right now, you know, 85 or 86,000 megawatts. I mean, it's gigantic. So obviously, you know, there's some financial considerations in them reversing course there in that.
Certainly.
Thank you.
Thank you, Senator. Senator Hughes.
Thank you, Mr. Chairman. Mr. Hill, thanks for being here. And a couple of follow-up questions on BlackRock. And as we have each discussed, they're and Senator Middleton noted, we're not sure why, but they're doing some things that we appreciate. And the votes, there's the perception that the votes have gotten better. The proxy votes have gotten better. We're still seeing some pretty disturbing votes. Let's talk about recent votes. Some examples of harmful shareholder votes by BlackRock recently. I know there are examples from the 2024 season, for example, with Wingstop. Do you have any information on that one?
I sure do. The question is how long it'll take me to find it. So just give me 2 seconds here.
No problem at all. I know
all this organized, but it's not.
No, you have a lot of information there. Most of it is committed to memory, but I know you want to get the details right.
Yes, I can right here. So there are multiple examples just from the 2024 season. In May of 2024, BlackRock voted for a proposal asking Wingstop, and who doesn't love their wings, to disclose short, medium, and long-term targets for measurably reducing its emissions and to report annually on its progress toward those targets. Now, for those who are uninitiated on this subject, you might, well, what's the problem with reporting? The problem is that as soon as they get a report on something, they start grading the executives against it. So a report on something is the same as basically saying we're going to start punishing you if you don't get along with it. This resolution requires setting targets and pushing a restaurant to restrict its own supply chain in order to meet ESG activist goals. It's not in the best interest of shareholders for Wingstop. And in addition to that, these types of emission requirements ask the companies to go all the way down their supply chain. So imagine you're a chicken farmer. You're not even publicly traded. You're a family farm. Wingstop is now going to be pushing on you to get your emissions to zero because they have to answer to Mr. Fink and to State Street. So these are incredibly damaging, not just to the companies themselves, but as a way to get into private. And this is something that BlackRock, back when they were bragging about how much they were doing, was talking about getting this down past just the publicly traded companies, but into the privately held companies. I'll give one more example. Second example involves Jack in the Box. BlackRock vote in 2024, BlackRock voted a shareholder proposal urging Jack in the Box to determine and disclose short, medium, and long-term goals for reducing its emissions. And BlackRock's vote was crucial to passage. The proposal received only 55% support, and BlackRock owns over 15% of Jack in the Box stock. So this is also not in the best interest of the shareholders. And my understanding, I have to go back and look, but I think the proposers in both of these situations was PETA or groups associated with PETA. So they're not even really about the emissions themselves. They're about the reduction in the consumption of meat overall, which is a overall target part of net zero. They want ruminant meat, meaning red meat consumption, to come down by 50% in order to hit targets. But what kind of shareholder proposal could possibly be in line with the company's future if it's about getting rid of their main product? So that gives you two recent examples.
It makes sense. Let me ask you about energy companies, because again, those are of a special concern in Texas because it represents such a vital part of our economy. The information I have says that in May of 2024, shareholder proposal 3 at Berkshire Hathaway, again, asking for disclosed greenhouse gas emissions data by scope and progress, and what's your progress toward net zero decarbonization? Do you have information on that?
I do, and I'll just note that this is something that has kind of spilled into the public arena. As of late, the Berkshire Hathaway really resents, given their unimpeachable record of wise investments, being second-guessed by Larry Fink, who, you know, some of his investment calls haven't been the best. He said the next 1,000 unicorns would come from green tech. He said that the BlackRock Investor Institute recommended tripling people's exposure to China, if anyone knows about how their stock market has been since that call has not been the best. So the idea that he would be second-guessing Warren Buffett and at that point Charlie Munger really raises the question of what this is really about. And in fact, Charlie Munger, before he died, said, you know, I like Larry Fink, but I don't remember electing him emperor, and he's acting like an emperor. And so I think that raises the questions. There's also another one in April of, this I guess was in 23, but it was a resolution for Newmarket to publish their GHGs, which is another energy related company. So it's a continuing problem. They have reduced it, but again, the right number here is 0. And I think people sometimes hear a number of like, oh, they only voted for, I'm just making up a number, 50% of proposals, like we've seen with ISS. They brag about, we're middle of the road, we only vote for 50% of the proposals. But those 50%, the 100% of those proposals are radical left-wing proposals. So you're not in the middle, you're just not as far left as you could be. And that's sort of what we see here with BlackRock reducing the number of radical proposals it's voting for. They're not centrist. They have not corrected the ship.
Let's talk about ISS. Again, a proxy advisory firm. And I will say about ISS, they did testify, of course, at the Marshall hearing under the threat of subpoena, but they also testified at our interim hearing, and we appreciate that. We've worked with them on scheduling, and they have agreed to testify before this committee. We're just working on the date, so we don't want to put them in exactly the same category for cooperation on these bills as BlackRock and State Street. Let's talk about ISS. Of course, again, last year, the information we have says that they recommended in favor of shareholder proposals brought by animal rights activists, similar to what you talked about at Wingstop, Dine Brands, trying to force these restaurants to cut down on emissions in the supply chain. Now, again, if the proxy advising firms are supposed to be advising these companies to vote in the interest of maximizing shareholder returns, how does it make sense for a food company, for a restaurant chain to cut down on its supply chain emissions?
There's absolutely no way that this makes any sense at all. And in fact, the only way you could make a financial argument for this, and I will refer to Attorney General Paxton's lawsuit, is if you owned the entire market and you were intentionally trying to tank the supply so that you could profit off of the increase, which is part of what has been alleged in the manipulation of BlackRock and others in State Street with the coal market. So if ISS, I guess, is playing antitrust games, then this would make a lot of sense. But outside of that, there is really no shareholder value justification for telling a company to reduce the production of its own product when there is a overwhelming demand and continued demand for it. So it's just flat out, there's no justification for it. And again, the proposal wasn't even put in by somebody who even ostensibly cared about shareholder proposal or shareholder value. It was just a way to reduce the consumption of red meat and chickens.
Mr. Hill, thank you for this, and we'll move on in the interest of time. But if I were to ask you about their vote in favor of a proposal to force Chevron to set medium and long-term targets to reduce Scope 3 greenhouse gas emissions consistent with the Paris Agreement. Chevron, another example. We could go on, but you have more of those you could give us, I assume.
Yeah, I could sit here and you know, if it was not for the late hour, I would filibuster all of you and bore you to tears on the number of votes that they violated the shareholder proposal or shareholder value and their fiduciary duty on. But I appreciate the opportunity to highlight some of the ways in which the problem is still not over.
And we'll share those with the committee briefly on State Street. Jumping back to State Street.
Yep.
Again, if we were to talk about their net zero asset management commitments to push all assets toward net zero, as long as, for all their protestations that they are doing better and that they are not punishing energy, not punishing the Texas economy, is it fair to say that their votes and the organizations they join and the positions they take are harmful to the Texas economy, to Texas energy, and the Texas retirees?
That is 100% correct. And without boring you to tears on some of the votes that they've taken, which include not just anti-economic votes, but also votes in favor of race and sex-based quotas, which is a whole nother issue. We focus a lot on the net zero, but I think most Texans would find that particularly offensive, that their money is being used to push race and sex-based discrimination. In addition to that, I will just note that while BlackRock has left net zero asset managers and the organization has suspended its operations for now while they review, State Street still has not. And therefore, they still have the same commitments to that climate cartel that they did before. So that battle is, again, still not over. State Street, you would think they would be running as far away from this as they could, and they're waiting to find out what the new iteration of NZAM will look like before they decide. It seems pretty clear, given where this committee is, where Save Texas is, and a whole host of others, that the clear decision is to get out of NZAM together. And I think it speaks to their reluctance to actually clean things up unless it's forced at every given inch.
Thank you, Mr. Hill. Thank you, Mr. Chairman.
Thank you. Thank you very much for your testimony. The chair calls Jack McFerrin, Jasek Isaac, Steve Gassenberger, Robert Gordon, and then Brent Bennett. Those are the 5 registered for the bill. Mr. Isaac, welcome. Please state your name and position. And
there we go.
You may begin.
Thank you, Jason Isaac, CEO of the American Energy Institute, in support of Senate Bill 312. Members, I live a high carbon lifestyle, and I think the rest of the world should too. There are no low energy, therefore no low carbon wealthy countries. I think the rest of the world should get to live the high carbon lifestyle because look at us here in the United States. We have economic prosperity. We have environmental leadership. Over the last 5 decades, we've reduced pollution nearly 80%. We're world leaders in clean air. Over that same time frame, we've become #1 in the world at access to clean and safe drinking water, something that we take for granted, something that billions of people around the world don't get to experience. Places that live at net zero spend countless hours a day walking to collect water. Today, while we're here in the Capitol, women that living at net zero, women will spend 200 million hours walking to collect water because they live a low-carbon lifestyle, and I think the rest of the world should live a high-carbon lifestyle. So I'm glad we're talking about emissions while we're here and some of the politicization and the ideologies that we're seeing pushed on us. Senate Bill 312 is a vital step toward restoring fiduciary responsibility and financial common sense to public retirement systems. This bill is about math, ethics, and constitutional duty. Pension fund managers have one job: deliver the best financial outcomes for Texas public servants, period. Senate Bill 312 draws a clear line in the sand. Investment decisions must be made solely on financial factors, not on social, political, or ideological agendas. Unfortunately, we've seen how large asset managers and proxy advisory firms have manipulated our retirement systems into promoting ESG activism, often at the expense of returns. Senate Bill 312 changes that. It requires all contracts with investment managers and proxy advisors to commit in writing, much like many businesses in Texas have to commit that they don't boycott, divest, or sanction Israel or fossil fuels. They have to prioritize in writing that they prioritize financial returns over ideology. In 2022, my former colleague here at the table and I at the Texas Public Policy Foundation found that proxy advisors working with Texas pension systems, the employee retirement system, and the teachers retirement system recommended votes that directly undermined Texas laws and values, recommending that they support measures that include supporting climate alarmists and abortion-related shareholder proposals and board resolutions. These recommendations were adopted without scrutiny by ERS and TRS in lockstep with ESG activists. It's interesting, Chairman Hughes, you mentioned in the layout talking about bonds. There was a report that's was published in March of 2024, kind of discrediting and kind of bashing Senate Bill 13 and Senate Bill 19 that were both passed in 2021. The Texas Association of Business Chambers of Commerce Foundation published a study claiming that underwriting costs for municipal bonds in Texas more than doubled in 2022 and 23, adding an average of $270 million in direct cost each year. However, the study used the wrong data for its analysis, and using the correct data shows no significant increase in the cost of bond issuance in 2022 and 2023 compared to the historical average. The findings suggested that the legislation has had significant economic cost and should be reconsidered. However, the Texas Bond Review Board, they carefully track such cost each year, and their annual reports are the primary sources of the data. And they used a different weighting scheme in both 2022 and 2023, and then they corrected that data in a May update to those reports. The author of the Texas Association of Business Chambers of Commerce Foundation study never corrected its analysis and still continues to use that report to date. The correction in the study claimed that nearly $700 million in economic losses were entirely moot. The correct data shows that the average underwriting cost in 2022 and 2023 was $6.38 per 1,000 of bond issues, not $12.03 as claimed in the study. And it says here that it's interesting to note that the highest year for cost for bond issuance was in 2019. That was 3 years before Senate Bill 13 and 19 took effect. I know we're talking about public pensions here. It's incredibly important that we push back on the political ideology and ESG and support Senate Bill 312. Thank you for the opportunity to testify.
Thank you. Mr. McFerrin.
Mr. Chairman, members of the committee, my name is Jack McFerrin. I'm a research fellow with Heartland Impact, and I'm for this bill. In recent years, a growing number of investment decisions and corporate governance outcomes have been influenced not by the financial interests of shareholders, but by the ideological ESG goals of asset managers and proxy advisors promoting stakeholder capitalism. At the center of this shift are the big three asset managers, BlackRock, Vanguard, and State Street, which collectively manage approximately $24.5 trillion in assets as of the end of 2024. Specifically, BlackRock manages approximately $11.6 trillion, Vanguard $8.6 trillion, and State Street $4.3 trillion. The big three consistently funneled their clients' investments into ESG-focused funds, And like the gentleman on my left referenced earlier, these investments typically underperform their traditional counterparts. And in fact, a March 2025 report from Morgan Stanley found that sustainable funds delivered returns of 0.4% compared to returns of 1.7% delivered by traditional funds. Moreover, because these asset managers are the dominant shareholders in many of the largest public companies, they wield immense voting power at annual meetings and have the ability to sway or control corporate decisions through proxy voting. And I referenced this earlier, ISS and Glass Lewis were at the heart of this, but BlackRock, Vanguard, and State Street organized the ExxonMobil board of directors takeover. They were involved in the Chevron board of directors takeover, and they have been involved in many others. Ultimately, this concentrated power structure creates a system where a small number of ideologically aligned institutions can impose ESG mandates across the corporate economy, often at the expense of shareholder returns, fiduciary responsibility, and market neutrality. Passing SB 312 would help protect Texans from that influence and ensure the long-term health of the state's pension systems and Texans' pocketbooks. Thank you for your time.
Welcome. Introduce yourself. Give us your testimony. Go ahead.
Chairman Hughes, members of the committee, thank you for the opportunity to testify on this important bill. I'm Robert Gordon, the Senior Vice President of the American Property Casualty Insurance Association. APCI represents over 2/3 of the home, auto, and business insurance industry. And insurers are becoming increasingly whipsawed by the pro and anti-ESG political demands. So insurance in Texas is required to be priced on an actuarial basis, and all insurers do that. We don't price based on ESG or DEI. And boards of directors of publicly traded insurers, they have a fiduciary duty to act in the best interest of their shareholders, and that means making individual strategic decisions about which markets to serve and how to protect their reputation. Some strategically pivot to green markets. Many are focused on expanding their energy underwriting in states like Texas. But we're seeing increasingly those board strategic decisions on what's in the best interest of shareholders are being challenged by the activist shareholders that you've been hearing about all evening, who purchase a minimum number of shares to be able to offer these resolutions demanding a particular political agenda. And they usually use this cookie cutter language for all sectors that conflicts with the unique, extensive state regulation of insurers and creates a lot of regulatory conflicts. And we have reached out and talked to the proxy advisory firms and the investment advisors to explain how those proposals conflict with state law and create liability and are not in the interest of the shareholders, but despite being made aware of the significant harm, they continue to support those proposals. So we're getting caught in the middle. We think it's very understandable. You don't want state agencies to support these activist proposals that are antithetical to state pensioner financial returns. In fact, Bloomberg just announced that in the global market for environmentally sustainable funds just had its worst quarter in terms of redemptions. So we think resolution of important environmental, social, and governance issues, those need to be done by legislatures, people like you, not by these proxy advisors and asset managers using the shareholder proposal process to weaponize financial sectors like insurance that are essential for protecting society. We're a very competitive industry. We want to do business with you in Texas. Help us help you, and thank you for the opportunity to be here.
Thank you. Dr. Bennett?
Thank you, Chairman Hughes and members. Brent Bennett with the Texas Public Policy Foundation testifying in support of Senate Bill 312. I want to circle back to what Mr. Isaacs said and the pensions and the role of the pensions here. The discovery that was made 3 years ago of a lot of the votes being cast for anti-energy shareholder proposals was facilitated by the fact that the teachers and employees retirement systems were posting their votes publicly. And that's something I think that's a real key aspect of Senate Bill 312 is that, as the ground shifts one way or another on ESG, it's hard to, the way to ensure that we have compliance is to, be actively monitoring and have standardized reporting of proxy votes. And also the other thing too is that, ensuring the votes are cast correctly, right? You have to have the correct policy, transmit the correct instructions, and monitor compliance. And that's what Senate Bill 312 will help accomplish. And the example of how this works is the way changes that TRS and ERS made. So prior to 2022, ERS was voting for roughly 40% of ESG shareholder proposals at major U.S. energy and finance companies. That's shown on page 2 of my written testimony. And TRS is actually voting for more than 70% of such proposals. After TRS and ERS began to change their voting practices at the behest of this committee and the legislature, and during that time, and then in 2023, starting in 2023, once they implemented those policies, they've cast no votes in favor of anti-energy shareholder proposals. So what that shows is twofold. First is that these proposals don't have much bearing on actual company performance. Otherwise, they would have valid reasons to continue voting for them. Secondly, it ensures that having standard policy and transmitting the correct instructions, you can achieve proper compliance through that, and this bill will ensure that that is done across all Texas pensions. The last thing I want to note is that it's also important that the Senate Bill 312, the provisions that require regular reporting of the fees, returns, and net asset value of all the outside investments, particularly private assets, which are becoming a larger portion of what our pensions are investing in. Given that increasing amount of money being devoted to private equity and private credit, this transparency will help the legislature ensure that sound fiduciary practices are being followed in all these investments, not just in their public equity investments. And so we applaud the work of this committee and the legislature and hope it will continue to keep on the ball until these policies are implemented across all Texas pensions and endowments. Thank you.
Thank you. Members, questions of this panel? Senator.
Thank you, Mr. Chairman, and I thank each witness. Thanks for staying late with us. Representative Isaac, there was a discussion earlier about Chevron Scope 3 emissions. Do you have anything else on that?
Yeah, absolutely. I appreciate the opportunity to answer the question about Chevron and their Scope 3 emissions. It's even under the Biden administration, the SEC pulled their guidance, pulled their recommendation for the requirement to report Scope 3 emissions to publicly traded companies, citing the difficulty in calculating those emissions, but the absolute increase in cost to do so. It's essentially asking Chevron to encourage their customers to use less of their products. It's tracking employees' commutes, even if they're home office or remote-based employees. The difficulty with Scope 3 is it's practically impossible. And then again, when you look at the fact that reducing emissions doesn't do anything to mitigate a changing climate, it just makes everything more expensive. There's been numerous studies that have come out recently that have shown man's contributions of greenhouse gases over the last 200 years have had no impact on temperature on the planet, and that CO2 emissions are increasing because of warming, and that warming is primarily driven by the sun. Maybe that's why they're trying to blot that out now. It's mind-boggling to me. But what's interesting is we see companies leaving California because their egregious abuse of these environmental laws and pushing these political agendas on companies. Many energy companies are leaving or shutting down refining operations in California because they can't meet their requirements to report on Scope 3 that California has. But what's interesting now is California has just passed a law that goes into effect January 1 of 2026, that every company doing a business in the state of California has to report their greenhouse gas emissions, Scope 1, 2, and 3, everywhere they do business. Everywhere. It's a massive abuse of extraterritorial overreach that California is imposing on every single company that sells products or services in the state of California. That should be addressed in legislatures around the country, pushing back on California's extraterritorial overreach. I've got a draft model. If anybody wants to file something late, let me know. But I appreciate the opportunity to answer the question about Scope 3 emissions.
Thank you. Mr. Chairman.
Mr. Chairman, just if I could add to that, because insurers have the same challenges with Scope 3 reporting. We're unsure, where do you even start trying to figure out for every car that an insurance company insures, what's its gas mileage, how much the driver is driving it? How does that change over time? It's just impossible to try and start to do that. And frankly, we don't know why every individual insurer should try that. I mean, are we supposed to start discouraging consumers from purchasing certain sorts of cars? So the Scope 3 reporting is very troubling, and there's got to be a better way of approaching the concerns that are underlying that.
Thank you. Thank you, Mr. Chairman.
Thank you. Members, questions? Thank you all, panel. We're going to close public testimony on Senate Bill 312 and leave the bill pending. Chair lays out Senate Bill 1367 and recognizes Senator Hughes on his bill.
Thank you, Mr. Chairman and members. Thanks, everybody, for staying up with us. We're coming to a close. Senate Bill 1367 is about the state prosecuting attorney's office and about their role to prosecute, expanding it to prosecute election crimes statewide. So many bills this session and previous sessions to address the problem of prosecution of election crimes in those situations where the district attorney may have a conflict, may lack resources, for other reasons may not be in a position or be willing to prosecute election offenses. And there's no prosecution because the Attorney General has been removed based on the Stevens decision from the Court of Criminal Appeals. So this bill responds to that, and it says we already have in the judicial branch the state prosecuting attorney's office, which would empower them to handle election crimes at any stage, including district courts. The focus is on election crimes. They're low volume, but critical for election integrity. It counters potential non-prosecution, again, because of resource constraints, political pressures, conflicts, and that's what the bill does. It would transfer oversight of the state prosecuting attorney's office from the Court of Criminal Appeals to the Texas Supreme Court for enhanced judicial alignment, and that's what the bill does. I'll yield.
Thank you. Members, questions? Hearing none, chair opens up public. Oh, Senator Birdwell.
Thank you, Mr. Chairman. I wanted to just one quick question, if I may, Senator Hughes. The change, we're on 1927. The change.
Yes, sir.
We're
at 1367.
Oh, I'm sorry, 1367. Okay, I'm sorry. I'm looking at a note here that says something about a previous bill named 19. Yeah, I'm on 1367. This changes the appointment of that prosecutor from the Court of Criminal Appeals to the Supreme Court. My presumption is that we're doing that to eliminate the appearance of undue influence. If I'm the prosecutor in the courtroom and the judges in that courtroom, I am dependent upon my job on those judges. In the same way the governor makes a nomination but the Senate confirms, the Supreme Court appoints and has the ability to terminate or withdraw that prosecutor, but he doesn't practice in front of the Supreme Court. He practices in front of the Court of Criminal Appeals so that his standard of performance is not subject to the court that he practices in front of, so that there's not an undue influence of the court justices on the employment of that prosecutor. Is that why we're doing that?
Yes, Senator. Thank you.
Okay. All right. Thank you. I appreciate it. Thank you, Mr. Chairman.
Thank you, Senators. Chair opens up public testimony, calls Ken Moore. Ken Moore. Anyone else wish to testify for, on, or against Senate Bill 1367? Hearing none, public testimony is closed, and Senate Bill 1367 is left pending. Chair lays out Senate Bill 1861 and recognizes Chairman Hughes on his bill.
Thank you, Mr. Chairman and members. Another bill, another approach to address this problem that is not to be underestimated. We think about our urban counties in Texas where most Texans live, where millions of votes are cast. And for election crimes, in many cases, there's no one minding the store. Senate Bill 1861 will establish a process for the Texas Court of Criminal Appeals to appoint a special prosecutor to review law enforcement reports on election law violations, deciding whether to pursue charges, decline action, or request further investigation. Again, current law, we require local district attorneys and county attorneys to handle election law violations, but they may have conflicts, political pressures, or limited resources, especially in jurisdictions with ties to the same communities or officials under investigation. Under this bill, law enforcement agencies can submit detailed investigation reports directly to the Court of Criminal Appeals, bypassing potentially conflicted local prosecutors, as we discussed earlier. The court appoints a special prosecutor to evaluate the report from law enforcement and decide, do we file charges, decline prosecution, or request more investigations? There must be prosecuting attorneys from areas not overlapping with the investigating agency's jurisdiction, unless a law enforcement agency with statewide jurisdiction, such as the Texas Attorney General's Office. That's what the bill does.
Thank you, Senator. Members, questions? Hearing none, we're going to open up public testimony. Ken Moore. Anyone else wish to testify? Hearing none, public testimony on Senate Bill 1861 is closed, and that bill will be left pending. Mr. Chairman, your gavel.
Thank you, Mr. Chairman. And with, though we say it frequently, we can't say it enough, with thanks to each member and their staffs, with thanks to our excellent committee staff, to the Senate team who keeps us operating here and keeps this place clean and the sound on, the tables in place, and all the witnesses, whether you're on for or against, and all those advocates, we thank each one of you. And if there's no other business, the Committee on State Affairs stands in recess up to the call of the chair. Good evening.